Yesterday, a video of a well-known politician came out on Twitter and caught everyone's attention. The title of the video was "Scrap the EU Human Rights Act." What followed was a series of responses from lawyers and members of the public alike. I listened and watched the video, and it is pretty much clear that this was an attack on the Human Rights Act. Continue watching to find out more. This is Kareesha bringing you law updates. You have probably guessed it. It was a video by Nigel Farage on EU Human Rights Act. What is concerning is that this video and messages like this attempt to mislead and misrepresent. Nigel Farage knows full well that there is no such thing called an EU Human Rights Act. There is the Human Rights Act 1998, there is the European Convention on Human Rights, there is the 1951 Refugee Convention, but there is no such thing as the EU Human Rights Act, which begs the question, why the title? Well, the only plausible reason for this is manipulation and creating dissension, as well as hatred towards the migrant community. And this is dangerous. The video talks about two cases where criminals have allegedly used the Human Rights Act to stay in the UK. Again, misleading. In the case of the Egyptian national al-Siri, I will not bore you with legalese, but the courts have found that not all the evidence were properly considered. That's very important. And that the case failed to be redetermined or decided again by the first tribunal, and that the correct legal test needed to be applied. At the upper tribunal, and to summarize, the upper tribunal found that he was a refugee, but that the onus was on the Secretary of State, Priti Patel's own Home Office, to prove with credible evidence that the offending conduct could in fact be considered an act of terrorism within the definition of the Refugee Convention. And the courts said, and I quote from the court's decision, the Secretary of State's grounds of appeal, by some measure, do not pass muster. So if the Home Office had done its job properly, perhaps the outcome would have been different. Instead of blaming the Human Rights Act, or by extension migrants, perhaps Priti Patel should be doing her job properly. So why are the likes of Nigel Farage and other politicians allowed to mislead when it comes to migration, immigration, or migrants? Because there is a belief that the Human Rights Act 1998 stops the UK from deporting foreign criminals. It was in the papers some time back. So to some extent, and this will shock many of you, there is sadly some truth in this. Some also believe that the Human Rights Act offers more protection to criminals, but that is not true. We do not have figures on this, but data from 2013 and 2014, if I'm not mistaken, show that half of the offenders in prison who tried to resist the deportation were from the EU. So if they sought to resist deportation, they would rely on EU law as opposed to the Human Rights Act 1998. Let us look at the law briefly. What we have a mandatory deportation order under the UK Borders Act 2007. So if a person is convicted of an offence and was sentenced to more or 12 years of imprisonment, there would be a mandatory deportation order issued by the Secretary of State. I've seen media reporting that if a criminal has been living in the UK since he was a child and is being sent to a country he knows nothing about, the court will not send him back. Again, that is not entirely true. The courts have not been prepared to accept this argument. If anything, the courts have been prepared to assume that integration in the UK can be broken by criminal offending. What about the well-known scenario if a foreign criminal has British children or a British partner? Well, again, there are legal tests that would apply when the court is looking into deporting the criminal, and these are quite hard to meet. The Court of Appeal set the bar extremely high in that area. It's something neither the media nor the politicians are willing to report or talk about. But what I am saying is that the current narrative that the 1998 Act somehow helps criminal is untrue and not supported by facts or figures. So instead, there is no point in blaming our judges, our domestic laws, lawyers, or even migrants. There is, however, a need to look deeper. In 2006, it was revealed the Home Office was simply ignoring foreign criminals that were being released. These foreign criminals were simply released in the community, and that's because the Home Office forgot to deport them. What that means is that these people are still in the community. So to summarize, the way the rules are now means that where a person has been sentenced to more than 12 months and cannot rely on the few exceptions provided for in law, the person or the criminal, the foreign criminal, will be deported. So why do we still have media reports and videos bashing the Human Rights Act and by extension migrants? Well, it is because it sells. It's a popular narrative, and it is also deliberately misleading in order to fit an agenda. We need to look elsewhere. It is said little knowledge is dangerous, and that saying could not be more applicable than when it comes to deportation of criminals from the UK. Thank you for watching Kareesha Law. Subscribe and like.